Presidente, señoras y señores, me gustaría dar las gracias a Ricardo Martínez y a toda la Asociación Profesional Española de Privacidad por la invitación y por el privilegio de poder dirigirles unas palabras en la ocasión del cuarto Congreso Nacional de la Privacidad. I'm very sorry that I cannot be with you in person. Unfortunately, today's Congress coincides with a very important visit to Europol in The Hague, the European Police Agency, for which my institution will soon assume supervisory responsibility. I'm delighted to be able to provide some ideas at the beginning of this very well-timed event. Señoras y señores, it is going to take several years before we truly appreciate the significance of what has happened in this month, May 2016. Like my dear friend Mar España, I represent an independent European Data Protection Authority. I monitor and enforce compliance among European institutions of data protection rules. My institution has always been fully supportive of modernization of the EU's framework for safeguarding privacy and personal data protection. We have engaged closely with the European Commission, Parliament and Council throughout the long reform discussions. We published 2 detailed policy opinions on the reform. Our second opinion was in the form of an app, as you know, free to download to any iOS or Android device. I believe that the General Data Protection Regulation is a massive achievement for the European Union. It is ambitious and forward-looking. It clarifies the scope of which companies and organizations are subject to EU laws. It modernizes and reinforces existing rights for the individual. It places a new emphasis on the role of technology for ensuring the data is held securely. It empowers data protection authorities individually and collectively. But the GDPR also, in my opinion, empowers controllers. Why? Because it gives them responsibility for their processing operation. Article 5.2 of the new regulation refers to a new principle, the principle of accountability, responsabilidad. Companies and other data controllers are no longer required to notify each processing operation to the local DPA. Instead, under Article 24, the controller should put in place measures which they consider necessary to ensure compliance. And they must be able to demonstrate compliance not through notification, but through approved codes of conduct or certification mechanisms, seals or marks. Let me try to put the GDPR in the context of the wider reforms. As you all know well, the EU data protection reform package is made up of 2 legislative proposals. GDPR itself, which, as you know, is directly applicable in all member states, and an important directive, which is to be transposed into national laws in Spain as well, which specifically covers data protection in police and judicial sector with regard to criminal matters. The same directive is an essential component of the reform, especially because of the concerns of citizens with how law enforcement handles personal information. It is especially important also because of the need, more than ever, in the wake of the terrorist attacks on Paris and Brussels, and with which Spain has long been, unfortunately, acquainted, for cooperation and information sharing between police forces across the EU. We too want police forces, public prosecutors and criminal courts to be effective in the prevention and prosecution of crimes. The directive reflects the necessary adjustments for these sectors. In fact, in addition to these 2 measures, we can add another 2. The reform of the e-privacy directive 2002/58 on the privacy of electronic communications, and the reform of the European Union Regulation 45/2001 on how European Union institutions handle personal information. The European Commission is expected this year to adopt proposals in these areas. In April, the Commission has launched a public consultation on the reform of the privacy directive. I cannot overestimate the importance of these rules. It is the only instrument in the EU law with specific safeguards for the confidentiality of communications, which is a crucial part of the right to privacy in the Article 7 of the Charter of Fundamental Rights of the EU. Of course, in the Internet age, communication mediated by service providers is ubiquitous. And in our view, all service providers need to be subject to consistent rules which fully protect the privacy of the individual, and these rules must be overseen everywhere by DPAs to ensure coherence and legal certainty for companies and consumers. Now, there have been many scare stories in circulation about how the GDPR is going to be a sort of enormous burden for businesses. For example, I know that in Spain, like most member states, data protection officers are not mandatory. Under the GDPR, with some exceptions, controllers will need to appoint a DPO. What role should she or he play? The regulation also specifies new obligations in the area of data protection by design and by default and impact assessments. It is true that handling personal information is not child's play. It is not a frivolous activity because it has an impact on individuals, on their privacy and freedom of expression, even on their human dignity. So, of course, these practices must be governed by clear rules. It is also true that when it comes to setting these rules, the European Union is in the global vanguard. We should be proud of it. But I've not seen any evidence that data protection rules have dissuaded any company from trading with the EU or from offering their services to people in the EU. On the contrary, I believe that the EU's robust framework for the protection of privacy and data protection presents an opportunity for businesses. My colleague, the Assistant EDPS Wojciech Wieworowski, attended last month a conference in London sponsored by one of the tech giants on how privacy had become a new competitive advantage. I'm not necessarily referring to the 28,000 new data protection officers who, according to the APEP, will need to be recruited in the next 2 years. I mean that the new rules will create opportunities to offer services which meet the growing expectations of consumers for transparency, trust and control over what happens to their personal data. These new rules also create opportunities to set new industry standards, codes of conduct and accreditation in collaboration with data protection authorities. It creates opportunities to develop relevant and easy to follow guidelines on compliance with these rules. One of the most complicated and heavily negotiated sections of the GDPR concerns the so-called one-stop shop. This innovation, as you know, aims to ensure that companies and individuals can go to a single DPA for questions on GDPR compliance. The current Directive 95/46 had not one short provision for DPAs to cooperate. And let me remind you that DPAs have always been able to find common positions throughout the Article 20 in our working party. But the GDPR prescribes in great detail how DPAs must cooperate, help each other and share information. You can read this in 6 articles from 61 to 66 of the regulation. Under the GDPR, we need to provide relevant guidance in good time and in consultation with stakeholders. My institution, the EDPS, will play a full role as member of the EDPB. It means that we have to work quickly and we have to be more smart. For example, we must make full use of the IT capacities available. And the new regime for sanctions is another innovation which makes big headlines. DPAs will have to work hard to ensure that the sanctions are applied consistently and fairly and reflect the need to prevent and dissuade harm to the individual of unlawful data processing. So I encourage you to work with Mare Spagna and her team to ensure that the new European Union consistency mechanism is responsive to the needs of industry. Señoras y señores, the future of data protection starts today. Muchas gracias por su atención. mis mejores deseos y que tengan una excelente conferencia. Thank you for your attention.